Thank you. Please be seated. Good morning to you. This is the time set for argument in our consolidated CRs 15-357 and 15-401. State of Arizona versus, is it Job?
Yes.
Job Douglas Wolf. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for a rebuttal argument. Counsel, you need to keep track of that time for yourself. We have read the briefs in conference this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant may proceed.
Good morning. I'm Jared Keenan, arguing on behalf of appellant Job Wolf. May it please the court, Job was denied a fair trial for two main reasons. First, he was denied his right to present a defense by the trial court's erroneous rulings regarding hearsay. Second, he was denied his right to confront his accuser by the misapplication of ARS 13-1421, Arizona's rape shield law. I would like to take these two issues in turn. Regarding the hearsay rulings, the prosecutor in this trial successfully argued that introducing the fact that a statement was made automatically meant that it was being offered for the truth of a matter asserted. The trial court accepted this misunderstanding of hearsay and prevented Job from presenting his defense.
May I ask you, on the hearsay, I'd like to talk about a particular question that defense counsel asked that the court excluded based on hearsay. And this is the question that the defense counsel asked your client.
That was you, was it not?
It was.
Well, nice to know that. Okay, I thought so, but I didn't want to put you on the spot. In any event, the question here was, would you and the victim ever talk about sex together? And then there was an objection. So my question to you is, and I'd like you to focus on the record, why was that question relevant?
That question was relevant because Job's defense was that Amanda, the alleged victim, had, over the course of months living next door to him, engaged in grooming behavior and ultimately seduced him on the night in question.
Is it fair then to say that the theory of relevance was that it showed that they had a candid, sharing conversational relationship, and that was kind of one of the steps to that this was consensual, not?
That is correct.
Okay.
So that was going to be an argument as opposed to having any expert who was generally called to testify about that issue of grooming.
Correct.
Okay.
Amanda, as the facts show at the trial, Amanda was 26 years old at the time. Job was 16. Job was prepared to testify that not only had they engaged in multiple conversations about sex and sexual activity, but that even at one point she sent him a text asking for marijuana. That was all of these things were excluded by the trial court based on the hearsay rulings that the court was making. That specific question.
When I was reading the opening brief, what concerned me in particular about this question was then the argument in the opening brief that would have then allowed your client to testify about other sexual activities of this particular victim. And thus, that type of evidence, and I know you're going to get to the rape shield law argument in a second, but that that additional testimony perhaps would have run afoul of the rape shield law. So I guess going back to the colloquy that you had with the judge at pages 124 and 125 of the transcript of March the 18th, it appeared to me that the only thing that you were trying to do is to show that it was relevant as to the question's effect or on your client. That basically he understood that, yeah, they could talk about sex and one thing would lead to another, but that was all that it was going to be. That was the only relevance was, or were you trying to show something that might have then gone to her prior sexual relationships or activities that then would have created a rape shield law problem?
The importance or the relevance of that particular question was to not only show that Job was aware that they could talk about sex, but on top of that to show the state of mind of Amanda, the declarant, that she had been engaging in this type of seductive activity with Job for some time. These conversations that they had didn't just take place on the night in question. The question was broader than that throughout the time that Job knew Amanda, that they would engage in these sexually explicit conversations.
Kind of what you're really saying is it went to both parties' state of mind.
Correct.
Okay.
But how does that question and answer? Did you talk about sex with the victim? And the answer presumably would have been yes. Isn't that so general as not to prove anything one way or another without some follow-up?
Well,
you'd have to give content to those conversations, wouldn't you?
That's correct.
And so what was the content going to be?
The follow-up questions would have filled in some of those gaps.
But with what?
With
See, the judge said, when you made this argument, look, all I asked was, did you talk about sex? And it doesn't require that question doesn't require that he even say anything about, in any details about what exactly they talked about. And the judge says, well, that's a subsequent question, as if he anticipated that you had some follow-up that was going to fill in this sort of general content. And then later, when you repeated, all you're asking is, did you talk about sex? And that goes to their relationship. And the judge said, if he talks about sex with her, with Amanda, yes. But you're talking about sex with her brother, or with his brother. And he said her brother, his brother. But the judge saw that the only relevance of what you're asking depended on what you were going to follow up with, and that's what he was trying to find out. Is that right?
That may be right. It's difficult to know specifically what the trial judge was seeing with regard to relevance, because the misunderstanding that sort of permeated all of the hearsay objections or his misunderstanding of hearsay, there's a portion in the record where he asks, well, if you're not offering it for the truth of the matter, how's it relevant?
Well, I mean, I have to say, in fairness, the prosecutor kept talking about hearsay. The judge was talking about some other stuff, and the judge seemed to have relevance concerns. That's what the transcript shows to me. And so, again, I guess my question is, you tried to restrict in your argument with the trial judge the discussion to the bare question and answer that you just asked and what had been objected to. Did you talk about sex? And the answer presumably would be yes. But the judge was focused on, well, where are you going with this? Because he wasn't going to let you get into something that he thought was improper. He thought it would be improper if you ended up discussing what she did with her boyfriend. He thought it might be proper if you had evidence that they talked about, the defendant and the victim talked about having sex together.
Correct. I think the problem, though, is that we didn't even get to the follow-up questions. The judge precluded us from even asking the general question of whether or not Job and Amanda had ever discussed sex. It seemed clear, at least to me at the time, that the judge was not going to let us go even answer that question, let alone these specific follow-up questions.
If that was all that came in, the question, did you talk about sex with the victim? And your client's answer, yes. What is the jury supposed to do with that? The jury's not going to know what you're talking about, are they?
Well, I think the jury would. Like I said, the situation that we had here was a 26-year-old woman who's claiming that she was raped by a 16-year-old boy, and the defense was positing that the 26-year-old woman was in fact the spider in the fly analogy, and that she had seduced the 16-year-old boy, and she was the one that in fact in this situation committed a criminal act.
I'm having trouble understanding how that question and answer makes any material fact easily resolved by the jury, more easily resolved by the jury, unless you say what the conversations were.
Again,
what the judge was worried about.
And I know, and I understand that the judge may have had that concern. My point was that we couldn't even get to whether or not the judge was going to allow us to follow up with specific questions because the judge had precluded even the general one.
You did not have evidence, and we're not proposing to establish that the conversations had to do with your client having sex with the victim.
No, the conversations between Job and Amanda would have all dealt with conversations about sex in general, about specific sexual activity that she enjoyed. None of this would have been offered to prove that she had in fact engaged in any of these sexual activities. It was just that it shows two things. Again, the impact on Job, the 16-year-old listener, and on Amanda's state of mind of what her intention was with having such sexually explicit conversations with a 16-year-old boy.
Well, I understand your point that if you were going to have your client testify to conversations he had with the victim, where the victim described, according to your client, described sexual conduct with her boyfriend, you would not be offering it for the hearsay purpose. You would be offering it, as Judge Norris said, for its effect on the victim and or you and your client. But then that, as Judge Norris pointed out, that raises questions about the rape shield law, which I guess we'll get to. But
correct.
I'm just having trouble seeing how the bare question and answer that we're talking about right now, what its marginal relevance was, if you didn't fill it in with something permissible.
Even if we were only allowed to ask that one specific question, did you ever talk about sex? And the answer was yes. The jury would at least then know that prior to this specific night at issue, Amanda, again, an adult, was having conversations about sex with the much younger brother of her boyfriend. And I think that is quite relevant, at least to argument, about whether or not the act was consensual.
If the jury got the idea from that question and answer that they were talking about sex she had with other people, then there's the rape shield law problem.
Well, that's a separate issue. I agree.
That would have left the jury with an impression that may not be permitted by law.
It may not. However, regarding the rape shield law, I think that the impression that the jury got was in fact false, but not in the way that the defense was positing. They got a false impression from the prosecutor and Amanda's testimony about the type of person she was and the type of relationship she had with her boyfriend. She mentioned that it was a perfect relationship, God-given. The prosecutor mentioned that they were talking about marriage. The type of impression that a jury gets from that type of those types of statements is not accurate. In fact, it's a false impression that the jury was left with. In fact, the prosecutor herself used that false impression when arguing. She asked the jury, why would Amanda have sex with the much younger brother, ruin her perfect relationship, and have sex with the much younger brother of her boyfriend, who's also a drug addict? The defense could not answer that question because the jury was only left with this false impression that Amanda and Jared were in this God-given, on the road to marriage, perfect relationship, and that was far from true.
Well, sir, are you arguing that this particular colloquy that we're talking about, that was, you offered that in rebuttal to this false picture?
No, the rebuttal evidence was going to come from Jared Wolf, Amanda's boyfriend, and Vanita Ritchie, Jared's twin brother's girlfriend.
You're not trying to justify this question and answer by responding to what you call a false impression.
No, Your Honor. I thought you had asked a question about the rape shield law. I was trying to address that.
Yeah, we can get to that. I just want to make
Okay.
sure we're off the other topic.
Yes. So regarding the rape shield law, again, the impression that was left by the prosecutor's argument and Amanda's testimony left the jury with a false impression of the type of relationship that she had both with Jared and with Job.
Forgive me, I was just looking at your opening brief, and maybe it's in there and I missed it, but where's the testimony relating to the statement you ascribed to the victim that her relationship with her partner was somehow blessed by God or in accordance with God's will or something like that? Where is that?
That's on page 8 of the second day of trial, March 17th. I believe it's page 8, line 22. She refers to Jared, her boyfriend, as God-given. It's the prosecutor that I believe mentions marriage in her opening statement. And again, in her closing, she makes a big deal about why Amanda would ruin this perfect relationship by trying to have sex or having sex with one of her boyfriend's family members. And the testimony of Anita Ritchie would have been able to answer that question for the jury because Amanda did, in fact, proposition another member of her boyfriend's family in the past.
Even if she was the Marquis de Sade, how do you get past the rape shield statute during the course of the trial without raising it as a pretrial issue?
Well, prior to trial, the defense didn't know that the prosecutor was going to make such a large deal of Amanda's sex life with her boyfriend. That happened.
But you would know that the rape shield was going to preclude you from asking her anything about her sexual history, period.
Up until the point where the prosecutor made...
No, the rape shield law prohibits information about a victim's sexual history from coming in, period.
Yes, but the rape shield law doesn't allow the prosecutor to create a false impression in the minds of the jury.
Well, but the evidence that came in, to build on what Judge Portly was saying, the evidence that came in was her statements that her relationship with her partner was perfect, and when you have a sexual life with a partner, you keep it between each other, basically keep it quiet. Now, forgive me, I don't remember the comment about God. I'll have to go back and look at that. So you read it to me, so we put that into the mix. That by itself, that's the state of the evidence. I don't see how that evidence or that testimony implicates and gives an exception during the course of the trial to this victim's prior sexual history. Now, argument's another matter, but at least as far as the evidence and opening the door, which is essentially the argument here, I don't see any door getting opened.
I would argue that the prosecutor and Amanda opened the door by these types of statements. But on top of
that by itself then means that a victim would put on, and then it can be cross-examined as to this victim's sexual history with others?
No, because that's not the only door-opening problem. The other issue that comes up that was raised by that was brought up by the prosecutor is Amanda changed her story. Early on, she had told the original the cops that showed up first one story, the scene examiner one story, and then at trial tells a different story. The prosecutor elicited testimony from Amanda and argued that the reason that she changed her story was because she was embarrassed to tell the original officers, who were men, as well as the female scene examiner, information about her sex life. And I think that with the painted picture that this woman is in a God-given relationship, she keeps her relationship between her and Jared and only her and her boyfriend, that the government's argument about why her story changed doesn't hold water. It can be challenged if we can show that she in fact doesn't keep her relationship between her and her boyfriend and only her and her boyfriend. So both of those reasons, the picture painted by the prosecutor as well as the prosecutor's attempt to downplay or explain away Amanda's change in story, both go to the relevance of this testimony from Vanita Ritchie and Jared Wolf. And if there's no further questions, I'd like to reserve my time for rebuttal. Thank you.
Thank you, Mr. Keenan.
May it please the Court. My name is Adele Ponce, and I represent the state of Arizona, the appellee in this matter. I'll begin by addressing appellant's claim regarding the alleged conversations about sex, and then address separately the rape shield matter. The trial court did not abuse its discretion in precluding the alleged conversations about sex in this case. The court acted well within its broad discretion, anticipating assertions by the victim regarding her sex life with her boyfriend, Jared.
But what was wrong with the first question? Did the two of you ever talk about sex? Neither. It may have marginal relevance, but apparently is relevant. Not hearsay.
As the court indicated, the trial court was concerned about what other testimony this might lead to, what the appellant might disclose in answering that particular question.
But that's what trial judges do. They take one question at a time and they rule on any objection that's made. And unless it goes far afield, a trial judge can always cut off an answer and tell the jury not to consider anything other than a yes or no answer to the question.
I think also the particular relevance of the answer to this question wouldn't have been apparent to the court at that time. I mean, the alleged conversations weren't alleged to have occurred on that night. The question, as you indicated, was general about what they had talked about in general at some time before the night in question. And the appellant, when questioned about specifics regarding alleged flirtatious behavior by the victim, hadn't come up with any examples, certainly hadn't referred to any explicit or hypersexualized conversations he had that had turned him on, as he now claims. Certainly hadn't alluded to any of the specific statements he's now brought up on appeal to say that he would have testified to had he been permitted to.
Isn't the starting point first? I mean, you have to start somewhere in these type of situations. And the starting point is, have you ever talked about sex with the victim? The answer is obviously going to be yes. It has to be. Otherwise, why bother to ask it? So it has to be yes. Then maybe, or maybe not, but let's say maybe he would have been asked some other questions about flirtatious conduct or conversation, and maybe that would have been a step too far, and he would have kept it out. But we'll never know because he never got to be able to ask the very first fundamental question.
Even if this court finds that the trial court abused its discretion in precluding the witness from answering this particular question, really any error was harmless here because, as the court indicated, testimony that the victim and appellant talked about sex didn't reveal anything in particular about the night in question and what happened here, which was the real issue in this case.
But the defense's argument is essentially, to put it in the vernacular, she was leading him on. It's like grooming is kind of one of the arguments, but she was leading him on. She was kind of inviting him. She's 26, much older. He's 16. She was really kind of encouraging him to go forward. And so, given that you have to start and painting that picture, did you talk about sex? Yes. Then there might have been additional evidence to show that they did have this flirtatious conduct, and then, of course, they start having drinks. One thing leads to another. I mean, he has to have an ability to set the stage for the argument this was consensual.
But the particular fact that they talked about sex doesn't reveal anything about whether she let him on or not. We don't know.
But isn't that relevant as to a step? I mean, I know I'm an old fogey, but if I have conversations with a much younger man about sex in a somewhat suggestive way, doesn't that perhaps give rise to perhaps an inference that a fact finder could take if combined with other things, other information, that perhaps the relationship went beyond just simply a platonic friendship?
Potentially, and I think the appellant's claiming here that the jury needed to hear this information to show that the victim was sometimes inappropriate with him. But the jury heard testimony about the victim's cobwebs comment that she made on the porch. He also testified that she told him secrets. He testified that he saw her drunk on a number of occasions, that she would ask him for cigarettes. He testified that she told him she'd had her tubes tied. She was described by his father as someone who was sexually speaking. The jury heard all of this testimony and wouldn't have gained very much from also hearing that they spoke about sex. The jury convicted him because the story he told about what happened that night didn't match the evidence that was presented in the case. In fact, contradicted it, particularly with regard to the story he told of a consensual encounter initiated by the victim. Was directly contradicted by the texts that were introduced in this case. His account of an hour and a half consensual sex in her bed didn't account for the bruising that she received on her left side, which she indicated she obtained when she was wedged between the bed and the table. And the story he told was really not particularly believable. This story that this same woman who is receiving these texts for over 2 hours looking for excuses to come to her house, telling him good night, telling him she's feeling horrible, that she subsequently sat for 10 minutes at her table and drank shots with him, threw up in her bathroom, and then pulled him into her bed where her 2-year-old child was sleeping and had sex with him for an hour and a half. His account that he wasn't worried the child would wake up because she called him Uncle Bubba, but that when this is all done an hour and a half later, and he's telling the victim that he's going to tell his brother that when the child does wake up, he covers her head with a blanket, runs out the door, and actually never tells his brother, tells him that nothing actually happened. The jury convicted him because that story was not credible and didn't correspond to the evidence that was introduced in the case, not because of information it didn't receive about the victim's conduct with the appellant in this case. I'd also add, as the court indicated, the particular statements that he claims he would have introduced that he says would have been relevant to show how inappropriate their relationship was would have been precluded under the rape shield statute. Appellant would have had to file a motion, would have had to have a hearing to establish by clear and convincing evidence that these things that he testified about actually occurred. And the testimony really didn't fit under any of the categories outlined in the rape shield statute for admitting this type of testimony.
If he had filed the pretrial motion, and to the extent information could have been developed, would it have been admissible in an effort for impeachment purposes? Generally, as opposed to maybe specifically.
It wouldn't have been admissible for impeachment purposes. No. I mean, the conversations about sex don't qualify under any of the categories here. I mean, as far, if you want to address...
Well, if it would specifically impeach, at least the impression, as we've heard this morning, that he was fairly monogamous. Given all the other evidence you've talked to us about.
No, so the trial court... the trial court never got a chance to apply the rape shield statute to these particular statements he wanted to bring in. But the court did apply the rape shield statute to preclude other evidence he wanted to bring in about the victim's prior sexual conduct with women. This really would have been the same insofar as if his claim for bringing it in was to impeach the victim. Again, nothing that this victim said put her sexual conduct in issue in order to permit him to bring in this evidence. The victim's statement explaining her embarrassment and speaking to police about the details of her attack didn't open the door to bring in this irrelevant information about her prior sexual conduct with women or any conversations she had with him about her sexual life. the victim's testimony about her relationship with Jared or the prosecutor's statements about her relationship with even her sexual relationship with Jared didn't open the door. She certainly didn't state that she was monogamous, nor did she imply that she was monogamous. Appellant seems preoccupied with the idea that the jury had the impression that she was monogamous. But if the jury had that impression, it wasn't based on anything she said. Her testimony didn't paint her as any kind of prude or chaste woman by any stretch of the imagination. And if the jury had that impression, this was based on an impression that they came to the jury box with, an impression about women, an impression about victims of sex crimes, not based on anything she said in particular. And for appellant to argue that he should have been able to disabuse them of that impression, to bring in this irrelevant information about her prior sexual conduct to show that she was in fact the type of person who would have consented to sex with him, that's exactly the type of testimony that's precluded under the Rape Shield statute, and that the Rape Shield statute intends to combat. Now, in addition to the fact that none of her statements opened the door to bring in this information, the court separately found that it was not relevant to the issues in the case. Under the Rape Shield statute, it's not sufficient that the state opened the door. The court must, in addition, find that the information is relevant to the issues in the case. And here, the victim's prior sexual conduct with other women had no bearing on the question of what happened between her and the victim that night, unless the jury makes an inference that's not permissible under the Rape Shield statute. And separately, appellants claiming that he should have been able to bring this evidence in to impeach the victim, but this court held in Herrera that a defendant can't bring in this type of irrelevant information under the guise of impeaching the victim unless it has something more, some other connection. There's some other connection between the prior conduct that's going to be discussed and the actual allegations or crime charged in the case. And there was no such connection here.
What is an example of the extra that Herrera was talking about?
Well, it didn't give an example, but I think certainly evidence that the victim had engaged in prior sexual conduct, actual sex acts with the defendant would be something that could potentially have some kind of connection. Or if she had stated to him in the past, I would really love to have sex with you someday, this would be a type of evidence that would be potentially relevant or bring that connection. But what we do know is that the evidence that was introduced in this case didn't have that connection, or that the appellant was attempting to introduce in this case didn't have that connection to what actually happened in this case.
I pulled up the March 17th transcript. I'm looking at pages 8 through 10. And I think it's fair to say, A, the victim was pretty plain speaking, pretty direct in her discussion of her relationship with her partner. And B, presented a situation where she was very happy in that relationship and would not have done anything to jeopardize it. Not that she was in a sense, it's kind of similar to saying she was monogamous, but basically she was not going to jeopardize it. She was not going to risk it. She was happy with it. Therefore, the evidence that she had a relationship with another family member, why isn't that relevant? Why isn't that really relevant to impeach her? Forgetting the other situation, I agree with you on the other situation, that whether she had had a relationship with a friend. Let's put that aside. That doesn't seem to be pertinent. Well, on the spectrum of relevancy, that one is on one end. But when she had arguably a relationship with another member of the family, doesn't that seem highly relevant to whether she was willing to stray within another family member, this defendant?
The argument that she had an interest in maintaining this relationship and therefore wouldn't have, done anything with appellant is not. It's not an argument about monogamy. I mean, the appellant even made that argument to explain why she would have called the police right away. He argued that because she didn't want to jeopardize her relationship with her boyfriend, that's the reason that she cried rape, according to him. That argument isn't an argument about monogamy. It's simply pointing out that she was in a relationship with a boyfriend and she wouldn't have slept with his younger brother. I mean, that isn't the type of argument that would open the door to bring in irrelevant and.
Wouldn't it be relevant if she, in fact, had relationships with another member of this same family? That's what.
Well, she didn't
not
have
just anyone in the world, but this same family.
She didn't have a relationship with anyone in this family. I think she propositioned the girl.
It was the wife of another member of the family.
It was the girlfriend of another member of his family, and the evidence at the hearing showed that she also indicated that the boyfriend would approve of this, that this wasn't something that he would have a problem with. And so in that respect, that testimony also wouldn't impeach her. The evidence was, because they had this woman come and testify, and she said that the victim had indicated to her that the boyfriend wouldn't have a problem with this if she did it. And so, in that respect, that wouldn't be particularly relevant. Appellant doesn't get to argue that just because the victim has had these other relationships with other people, even within the relationship with the boyfriend, that somehow made her more likely to consent to sex with him. The appellant makes much of the fact that the prosecutor argued, or an opening statement mentioned that she had been thinking about marriage. But if the victim had been married, if she'd been just a married woman and been described as a married woman, appellant would still not get to bring in this prior sexual conduct to argue that she was the kind of person who would consent to have sex with him. I mean, that's simply not allowed under the Rape Shield statute. That's exactly the type of argument, in fact, that the Rape Shield statute aims to combat, tries to preclude, and the court correctly applied the statute in this case to find that this would have been highly prejudicial to this jury, in this community, in this case, and that it bore no relevance whatsoever.
Isn't that the linchpin here, that it was very prejudicial?
Very prejudicial, yes. Highly inflammatory, as the court called it. This evidence of the victim's bisexual conduct with women, and really bearing no relevance whatsoever on what actually happened that night. I mean, the two accounts of what happened that night, the fact that she's had this prior contact with other women really is not relevant or an issue regarding anything that the jury actually had to determine or consider in this case. And if the court has no further question, I'd ask the court to affirm the judgments and sentences in this case. Thank you.
Thank you, Ms. Ponce.
Thank you. I'd like to address briefly, if I may, the issue of harmless error. I think that it's clear from the record that this was not harmless error. We have an instance in this particular case where we have testimony from not one but two jurors that explained that they were completely confused by the number of hearsay objections that were being made by the prosecutor, which made the testimony of Job just simply a mess for them. They couldn't understand what was going on. Now, the judge explains to them that sometimes there's legal issues that the judge needs to make a call on, and the jury may not hear the answer to those questions. But as we discussed today, those rulings, those hearsay rulings, were an error, and the jury should have heard that information. And the jurors made it clear to the court that if they had heard that information, it likely would have at least played a role in their deliberations. The prosecutor says...
But there's a lot of evidence that they couldn't have heard And like all juries, they get to wrestle with the testimony that they hear to find out the facts to come to their conclusion. And why is this any different than, any other complicated case?
Because the information and testimony that was precluded in this case was not hearsay, yet it was precluded under the hearsay rules. The jury should have
There
heard
was
it.
only one answer of a question, that we may be able to agree on, but the rest probably isn't coming in.
I would disagree. I would just ask the court to review the written pleadings and reverse the trial decision in this case. Thank you.
Thank you, Mr. Keenan. Thanks to both counsel. We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.